it's clear that the digital economy has brought enormous benefits to businesses, consumers, and society as a whole. It's also clear that we become significantly or increasingly dependent on a small number of large platforms that hold significant power in digital markets around the world.
You might have heard the expression, there are two sure things in life, death and taxes. But tax law is about a lot more than that. This podcast from the University of Ottawa Tax Law Society has two goals: to help students find careers in tax and to ask questions about the hidden side of tax, from cryptocurrencies and AI to the Pandora Papers, from funding universal minimum incomes to even what tax has to do with your favorite streaming service. As a former journalist and a first-year law student, I don't know much about tax law yet, but I do like when cities are clean and people are healthy, which are two places where tax money goes. This show is for beginners like me and experts like my guests who'll have some answers. Because if there are only two sure things in life, let's at least make sure the tax part is interesting. My guest today is Matthew Boswell, the Commissioner of Competition at the Competition Bureau of Canada. For students not familiar with competition, let's take a quick step back. Some people might be wondering why we need rules on competition at all, and why we shouldn't just let businesses compete. Paraphrasing the EU Competition Commissioner, competition is mostly good. More competition drives higher quality, lower prices, and more innovation. But sometimes competition can be inconvenient for businesses. We've heard more in recent years about bringing stateless companies to heel. For example, the prominent competition case of Apple in Ireland, where the company received subsidies that created a €13 billion tax break, which in turn created unfair competition. And here in Canada, the federal court recently ordered Google to turn over documents to the Competition Bureau as part of an ongoing investigation into whether the company's practices are hurting competitor ad tech services, resulting in less choice for the services, less innovation for the industry, and harming consumers. Meanwhile, competition overlaps with privacy and data, so a lot of people will be waiting to see how the upcoming Digital Charter Implementation Act will affect competition in Canada. That's all for another podcast, but still, Commissioner Boswell's job is a big one. He graduated with an LLB from Queen's University in 1997, then worked as an assistant Crown Attorney in Toronto before joining the Ontario Securities Commission. In 2011, he moved to the Competition Bureau and was appointed Commissioner in March 2019 for a 5-year term. Your career path seems to have a connecting thread in that you've been drawn to public sector enforcement, from prosecution to securities, now to competition. How has that changed over the course of your career?
Okay, so good question. I didn't start my career in the public or in enforcement. I actually was a summer student, articling student, and then associate at a pretty big Bay Street law firm. Law firm doesn't exist anymore. It merged with Gowlings and is now Gowlings. And so I was there and was hired back as an associate, but I knew that I didn't really have great opportunities there to get into court at any time soon. So I was fortunate enough to get an offer to become a Crown Attorney in Toronto, Western Toronto. And I jumped at it. I took a significant cut in pay overnight and discovered that it had been a great idea. I was in court immediately, which was a bit terrifying when you're all of a sudden prosecuting criminal cases. And I think that's where I got the sort of bug, for lack of a better term, of pursuing the public interest in my legal work. And people sometimes think, oh, pursuing the public interest means always pursuing convictions or findings of liability, or that's actually not the case. It's pursuing the facts, pursuing the evidence, figuring out what the situation is and whether or not the case ought to be prosecuted or resolved. Or so I did that as a Crown Attorney in Western Toronto for 7 years, I think. And I briefly went back into private practice and discovered that I missed the public interest work that I'd become so accustomed to doing, and doing more and more serious criminal cases. So at that point, I once again, through a friend, had an opportunity to become a securities prosecutor at the Ontario Securities Commission. And that was a great time, because they created a unit that was made up of ex criminal prosecutors and former police officers from all different levels and forces, and they created what they called the boiler room unit, which boiler rooms are, to give it a sort of brief explanation, are people who fraudsters, criminals who create fake companies, fake websites, fake everything. And at that point, we're hiring people to call telephone lists, and sell fake shares in these fake companies, with all sorts of promises of a IPO coming, and they were going to triple their money or whatever. Anyway, so the Ontario Securities Commission had the presence of mind, because this was becoming a problem, to create that unit. And we, vigorously pursued the people who set up and ran these frauds. So that was, once again, public interest work, and also did some insider trading work at the OSC. And then once again, ended up moving, just sort of through as a result of a connection to a friend, and I got offered a job as a senior person in the criminal section of the Competition Bureau, and took the job, meaning only to stay for 2 years. And that was 10 plus years ago. And here I am now, still pursuing the public interest, defending the public interest in many instances. And I enjoy it. I enjoy, the investigations. I enjoy the passion that people have at the Bureau for the public interest and protecting competition in Canada. And so that's kind of the trajectory. It wasn't part of a plan from the get-go in law school. I never would have thought for a second I would have been in this position when I was in law school. But, I think the most important thing, is just my personal opinion, is to follow what makes you happy in your work. Don't, obviously we all have bills to pay and debts to pay off and that stuff coming out of law school. But to the extent you can, follow the path and work that is going to make you happy, it gets you out of bed in the morning and you're charged up and you're interested. And it's not always easy, but it's stuff that you're passionate about and interested in.
It sounds like you don't spend as much time in court now, though.
That is true. So, and I guess that's a good way to answer how that's changed over the course of my career. So obviously, as a Crown attorney, I was in court pretty much every single day. And sometimes for lengthy stretches on long trials and things like that. And at the OSC, I was still going to court fairly frequently, either in front of the commission itself or into the provincial court system in Ontario. But I do think that as I got away from it, as certainly when I came to the Bureau, I realized that I got to a point where I didn't need to litigate all the time. Litigating is I think, a very tough line of work to be in here. There's a lot of prep that goes into those hours that you're in the courtroom to be properly prepared. So maybe it was I got old, and just realized that, that was a young person's game, and that maybe I'd take a step back, and I've taken a step back. Who knows what the future holds?
It's not like you're doing anything boring now. I mean, the meat of what you do, a lot of the digital transformation, a lot of the rise of big tech, that's the future. It raises a lot of public policy questions for tax policy too, as well as competition policy. And in both cases, there seems to be a push for greater international cooperation to ensure policy coherence and minimize gaps. What has the Competition Bureau been doing on the big tech front, and what are some of the challenges and opportunities you see from a competition policy perspective?
Good question.
Big question. Sorry.
Lots of answers in there. The rising power of big tech, that's the term people use, a major theme in international competition policy discussions around the globe, and has been for some time now. And in different countries, it takes even greater prominence. For example, in Australia and the United Kingdom, more and more in the United States, the discussions are becoming quite loud, quite that something ought to be done. We're having that discussion in Canada about big tech and competition policy, but it's not as loud yet in Canada. It's clear. It's important to remind everybody, it's clear that the digital economy has brought enormous benefits to businesses, consumers, and society as a whole. It's allowed us to connect. It's allowing us to connect right now and have this discussion and have it recorded with very little, it's something that was set up by you quite easily. Working, shopping, pursuing post-secondary education remotely, all of this is, technology has allowed these great advancements in society. However, it's also clear that we become significantly or increasingly dependent on a small number of large platforms that hold significant power in digital markets around the world, in e-commerce, in online advertising, in app stores, in social media. We all know that there's a small group that have this significant global power, economic power, and other power that's outside of the sort of Competition Act regime. Some of this, their growth is an inevitable, consequence of these markets, the markets themselves, the digital markets. They are data-driven and characterized by network effects in that they propel themselves, and the big get bigger in terms of economies of scale and scope. And then the whole market can tip. That is to say that it can literally be dominated completely by one company, one platform. So there are significant competition issues for consideration, and people have been struggling with them. Courts have been struggling with them in different cases around the world. And the concern is that these platforms have strengthened or entrenched their market power by engaging in anti-competitive conduct. That's the concern that's out there. And has been expressed by different competition authorities, different academics, different economists around the world. Whether it's suggestions that they've been buying up potential competitors or nascent competitive threats to acquire the software, or to shut down the potential competitor, excluding or disadvantaging rivals who compete on their platforms, or making it harder for people to switch from one to another. So it's critical that competition authorities, evaluate these issues, understand these issues, have the tools to investigate these issues, and to assess whether or not there are actually competition problems that need to be addressed in each jurisdiction. And the cooperation point is key now in the global marketplace, where competition authorities more and more recognize that we need to cooperate with each other. We need to communicate with each other more and more. We do cooperate a lot, and have for a long time, for 20, 30 years. but we need better ability to share information amongst different jurisdictions with respect to investigations into these sort of global issues. So, in fact, I was at a OECD session last week where we were all talking about, okay, how can we cooperate better on these investigations and enforcement? And there was discussion during that session on the tax cooperation agreements that exist at the multilateral level that allow, in fact, that facilitate, constant sharing of information with respect to various entities and individuals around the world who have, operations or presence in different jurisdictions. So the tax area is actually an area we're looking to follow in terms of our ability to cooperate.
I imagine every country would have a different amount of resources, amount of power to investigate. And is that a big element of Canada's involvement, benefiting from other people's resources and power, and also having other countries benefit from ours in some way?
Well, as you say, that there are varying levels of resources at competition authorities around the world. But the issue often is you have to look at it within the context of each country's laws. And they're not all perfectly aligned. They're not exactly the same in every country. So you get to a situation where the problems are very similar around the world, or the issues, I should say. And if there is an anti-competitive problem in Canada, we have to take steps to remedy it in Canada. We can't rely on other countries or hope that whatever another country does to remedy a similar anti-competitive problem is going to be applied in Canada, particularly when you're talking about digital platforms that they can modify how the platform works quite easily. They can modify the algorithms depending on the jurisdiction that they're dealing with. So you have to have a remedy or a solution that addresses the particular Canadian concerns. But we do cooperate. We do share information with other jurisdictions. We do obtain information from other jurisdictions. But there are, limits on that in our law that we have to respect, and there are limits on other countries on what they can share with us from the progress of their investigations. But we have been doing, at the Bureau, we have been bringing cases in the digital economy against large companies that operate in the digital economy for some time. Some of them have been smaller cases. For example, we had a case against Amazon related to some of its marketing practices and representations. We had a settlement with Facebook related to false or misleading representations as to how they were treating Canadians' private information and following their own privacy policies. We have publicly known active investigations into Amazon and Google right now. We recently obtained court orders related to the Google investigation for them to provide us with sort of information that we require to advance our investigations. And we're continuing to figure out, better ways to go about it to deal with, investigations in the digital economy involving big tech and how best to improve the ways we go about those investigations. We just created a new unit, a new branch within the Bureau, and new section of the Bureau called the Digital Enforcement and Intelligence Branch that will build up over the next couple of years, but it's designed with our ultimate goal in mind, was to be a world-leading competition agency in terms of how we deal with the digital economy and competition.
I feel like we could talk about funding for a long time related to those kinds of initiatives, because as these companies grow and as more are created, it's only going to grow the kind of research and investigations you're going to need to operate. But since this is really aimed at students and practitioners, specifically people who like law, but who also probably like competition, what advice do you have for the next generation of tax lawyers in terms of ensuring fair competition and reasonable tax for big companies?
Well, that's a tough question. Obviously, my area of expertise is broadly it's law enforcement and litigation related to law enforcement, and now it's competition law enforcement and enforcing the Competition Act. So I guess I would say, if people find their careers going towards tax law policy in Canada, I would recommend that they consider competition impacts of changes to tax law in Canada. If unintentionally, and this is often what happens, that policymakers are trying to achieve a certain policy goal, legitimate policy goal, but in so doing, they actually might be hindering competition by creating a barrier for small, medium-sized enterprises, or taxing, bigger firms in a different way that actually reduces competition in the marketplace because of the tax impact. So that's sort of domestically. And of course, there's the sort of competitiveness on the global scale issue that, how we structure our taxes in Canada, and whether that, how that impacts the competitiveness of Canadian companies who are trying to, go outside the borders and build their business outside our borders. So, those are some issues for anyone who might end up in policy. We have something called Competition Assessment Toolkit that's, designed for policymakers at all levels of government across Canada to assess that very question, whether the policy they have or are planning or building could unintentionally hinder competition and therefore hurt the Canadian economy, because competition is the greatest driver of productivity, innovation, growth, better products, better quality, and pushes down prices. So, from our perspective, we're certainly passionate about it, is that, we need to do everything we can to promote a healthy, competitive economy in Canada for the benefit of Canadians in the short, medium, and long term. So I'm not sure if that's helpful advice for private practitioners in the tax world, or students who are going to become private practitioners, but from a policy perspective, it would be, it's always helpful to keep that in mind.
Well, thank you so much for your time, Commissioner Boswell. I appreciate it.
Thank you, Amie. That was fun.
Thanks for listening to the Tax Law Society podcast from the University of Ottawa. Today's show was produced and edited by me, Amie Watson, with research and graphic support from Adriana Conti and Arjun Gupta, and audio engineering support from Max Desmarais of Mix by Max. The Tax Law Society is committed to helping law students find jobs and build careers in tax law. If you want to learn more, check out our website at www.taxlawottawa.ca.